There were 11 of them in that boardroom, and not one of them could look me in the eye. I remember the fluorescent lights above the table humming, that low, constant buzz that I'd always meant to report to facilities but never did. 22 years of small things I'd let slide. The coffee was bad, the parking was worse, the quarterly reviews were a joke. None of it had ever mattered because the work mattered. And then, in the space of about 12 minutes, none of that mattered either. My CEO, I'll call him what he was, a man who'd spent more time perfecting his LinkedIn profile than understanding what his own company actually built, slid a single sheet of paper across the table toward me. "We're restructuring the division," he said. "Your role has been eliminated." I looked at the paper. Then I looked at him. "Appreciated," I said. I stood up, buttoned my jacket, and walked out. Let me back up about 22 years. I grew up in Waterloo, Ontario, the kind of city where, if you were good with computers in the 90s, people either thought you were going to be very rich or very strange. In my case, it ended up being a little of both. I studied electrical engineering at the University of Waterloo, graduated into a job market that was just beginning to figure out what to do with people like me, and spent my late 20s doing contract work for 3 different firms before landing at a mid-sized cybersecurity company called Hartwell Systems in 2002. Hartwell wasn't glamorous. We weren't the kind of company that got written up in tech magazines or had a campus with a volleyball court. We had a parking lot with a pothole the size of a birdbath that lasted 14 years before anyone fixed it, but the work was real. We built network intrusion detection systems for financial institutions, government contractors, critical infrastructure, the kind of clients who couldn't afford to be wrong, which meant I couldn't afford to be wrong either. Over the years, I built something I was genuinely proud of, not just the software itself, but the methodology, a way of thinking about network anomaly detection that was different from anything else on the market. The core idea was simple to explain and incredibly difficult to execute. Instead of looking for known threats, the system learned what normal looked like for each specific client and flagged deviations before they became breaches. I called it adaptive baseline modeling. My team called it ABM. The clients just called it the thing that works. The key thing, and this becomes very important later, is that I developed the foundational framework for ABM on my own time, before Hartwell ever brought me on full-time. I'd been working on it during contract years, refining it, and I'd filed provisional patents through my own numbered company, 1847 Detection Corp., before I ever signed an employment agreement with Hartwell. When they brought me in as a full-time employee, I licensed ABM to Hartwell exclusively. I did not assign it. The distinction matters enormously as it turns out. My employment contract specified that innovations developed using Hartwell resources during working hours belonged to the company. ABM predated all of that. My lawyer at the time, a sharp woman in Kitchener who specialized in IP agreements, made sure the licensing terms were explicit. Hartwell paid me a licensing fee embedded in my compensation structure. They knew what they were getting. Or at least, the people who negotiated that agreement knew. The problem with companies is that people leave. And when the people who knew why things were set up a certain way leave, the institutional memory goes with them. By the time my COO joined Hartwell, about 4 years before all of this, he was the 3rd COO I'd worked under. He came from a consulting background, knew how to build decks, knew how to talk about transformation and optimization and strategic realignment. He did not know what adaptive baseline modeling was. He didn't particularly want to know. To him, cybersecurity software was a product, and products were line items, and line items could be evaluated on margin. He looked at my team, 12 people, most of them senior, none of them cheap, and saw cost. He didn't see what we'd built. He didn't see the 17 financial institutions whose network security depended on ABM. He didn't see the federal government contracts that specifically named our detection methodology and compliance requirements. He just saw salaries. I'd had that conversation with him twice in the year before the restructuring. Both times, I'd walked him through the numbers. Both times he'd nodded and said something like, "Absolutely, the technical value is clear," in a tone that told me he hadn't heard a word. The third conversation was the one with the paper. I drove home on the 401 with the windows down, even though it was October and probably 4 degrees outside. I needed the cold. My wife was waiting at the kitchen table when I walked in. She'd gotten a call from one of my colleagues about 20 minutes before I arrived, which tells you something about how fast news travels in a 12-person's team. She looked at me across the kitchen. "What are you going to do?" she asked. "I don't know yet," I said, "but I'm not panicking." That was true. What surprised me most driving home was how calm I felt. Not numb, calm. There was something that had been sitting in my chest for about 2 years, some low-grade tension I'd gotten so used to that I'd stopped noticing it. And it was gone. Just gone. My wife made tea. I sat down and called my lawyer. She picked up on the second ring, which is one of the things I've always appreciated about her. I told her what had happened. She asked me 3 questions. Had I signed anything today? No. Had I been asked to sign anything? No. Had I been given any severance documentation? Not yet. They said it would come by email within 48 hours. Good, she said. Don't sign anything until I've seen it, and pull out your licensing agreement tonight. The original, not a scan. I knew where it was. I'd kept it in a fireproof box in my home office since 2002. The severance package arrived by email the next morning. It was, I'll say, not embarrassing. 14 weeks at full salary, extended benefits for 6 months, a standard non-disparagement clause, and a non-compete that my lawyer flagged immediately. The non-compete was aggressive. It would have barred me from working in the cybersecurity sector in Canada for 18 months. My lawyer called me within an hour of receiving her copy. "They've included ABM in the schedule of company IP," she said. I wasn't surprised. I was actually a little impressed they'd found it buried in a schedule at the back. Whoever had drafted this on their end had done their homework, or at least tried to. "How much of a fight is this going to be?" I asked. "For them, significant," she said. "Your licensing agreement predates your employment contract by 14 months. The patent filings are time-stamped. 1847 Detection Corp. Still active and in good standing. There's no ambiguity here. They've listed IP they don't own in a severance agreement and asked you to confirm they own it. That's not a negotiating position. That's a mistake." I did not sign the severance agreement. 5 days after my termination, I got a call from a number I didn't recognize, Vancouver area code. The man on the other end introduced himself as the head of business development at Meridian Protective Technologies, a company I knew well because they were Hartwell's primary competitor in the financial sector. They were bigger than us in British Columbia and Alberta, scrapping for the same Ontario and federal contracts we held. He said he'd heard through channels. He didn't specify which channels, that I was no longer with Hartwell. He said his CEO wanted to have a conversation. He asked if I'd be willing to come to Vancouver, expenses covered, at my earliest convenience. I said I'd think about it. I called my lawyer. "Before you think about anything else," she said, "let's get clarity on what you can and cannot offer them and what any transaction would look like. And for God's sake, don't go to Vancouver without me." We spent 2 days going through everything. The licensing agreement, the original patent filings, the renewal documentation, the scope of what 1847 Detection Corp actually owned, which was more comprehensive than even I'd fully articulated, not just the core ABM framework, but 4 subsequent methodology patents I'd filed over the years as refinements of the original system. I'd always filed them through my numbered company. It had just been habit, honestly, the same way you might always use the same lawyer or the same accountant. But that habit, had it turned out, built a wall around something worth considerably more than I'd consciously appreciated. My lawyer's estimate, based on comparable IP transactions in the sector, was that we were looking at a floor of $400 million and potentially considerably more, depending on how badly Meridian wanted the exclusivity and what their strategic timeline looked like. I flew to Vancouver on a Tuesday. His lawyer sat peasy on the plane. The Meridian offices were in a tower downtown, about 3 blocks from the water. Their CEO met us in a boardroom with a view of the North Shore Mountains that I found genuinely distracting. I kept glancing past him during the conversation, which I don't think helped my negotiating composure, but there it was. He was direct, which I appreciated. He'd been in the industry for 30 years. He understood exactly what ABM was, what it did, and what it would mean for Meridian to own it outright rather than compete against it. "We've had our technical team review your filings," he said, after about 20 minutes of context setting. "We think the methodology is sound and the IP is clean. We'd like to make an offer." He slid a letter of intent across the table. I looked at my lawyer. She'd already seen it. They'd sent a draft the night before. She gave me a small nod. The offer was $680 million for full acquisition of 1847 Detection Corp., which is to say, for all the patents, the methodology documentation, and the corporate entity itself, plus a consulting agreement at $3.1 million per year for 3 years to assist with integration, and an option to bring on up to 8 members of my former team as Meridian employees at competitive salary. I took a breath. I appreciate the offer, I said. We'll need a few days to respond. On the way back to the hotel, my lawyer looked at me sideways on the elevator. You're shopping this, she said. It wasn't a question. I'm going to make one call, I said, just to know where we stand. That call was to a firm in Toronto I'd had preliminary conversations with twice over the years. A private equity group that had been sniffing around the cybersecurity space looking for a foundational acquisition. They had deeper pockets than Meridian and a different strategic objective. They weren't looking to use ABM to compete with Hartwell. They were looking to build an entirely new enterprise around it. I had my lawyer reach out on my behalf on a Wednesday morning. By Thursday afternoon, we had a meeting scheduled for the following Monday. By the end of that Monday, we had a competing offer on the table. $820 million for the full entity, no consulting requirement, but an offer of an executive role, Chief Technology Officer, at a base salary of $410,000 plus equity if I wanted it. I went back to Meridian. They came up to $795 million as I called the Toronto firm. They held at $820 million and added a signing bonus. I took the Toronto offer. The total transaction, $820 million for 1847 Detection Corp., plus the executive package, closed 26 days after I said appreciated and walked out of that boardroom. I should tell you what happened to Hartwell because I think it matters for the complete picture. When my lawyer formally notified Hartwell that we were rejecting their severance offer and providing documentation that ABM was not Hartwell IP, their response was initially aggressive. Their legal team sent a letter asserting that the company held rights to ABM through a theory of implied license that frankly made my lawyer laugh out loud. Not unprofessionally, but genuinely. Implied license, she said, setting down the letter. After a documented exclusive licensing agreement with specific terms and termination provisions. Bold. The litigation threat evaporated within 3 weeks. When your IP counsel realizes the opposing party has a 22-year-old time-stamped paper trail and 4 clean patent filings, the math on proceeding changes quickly. What did not evaporate was the operational reality. Hartwell's 17 major financial sector clients had network security infrastructure built around ABM. When the news broke, and it broke because these things always break, particularly when a federal procurement office starts asking questions about contract compliance, those clients started making calls, some of them to Hartwell, wanting assurances, some of them directly to me. I didn't poach. I want to be clear about that. I did not contact a single Hartwell client. But when a VP of IT security at a major bank calls you directly and asks whether the methodology underlying their breach detection system is going to continue to be supported, you tell them the truth. It will be supported. It's just going to be supported by different people now. 3 of Hartwell's top 5 revenue clients transitioned their contracts within 8 months. I'm told the board removed my former COO about 4 months after my departure. I'm told, not because I asked, but because a former colleague who stayed texted me one afternoon with just a news link and a single word, finally. The thing about building something real is that eventually people notice what happens when it's gone. 6 of my former colleagues joined the new entity through the process my lawyer and the Toronto firm had negotiated. My senior developer, who I'd recruited out of a graduate program at Carleton and spent 6 years mentoring, came over as lead architect. My former director of client operations followed 2 months later, once her notice period had elapsed. 4 others came in waves after that. We built the team we'd always talked about building, but never quite had the autonomy to build inside Hartwell's structure. No bureaucratic approval chains. No quarterly reviews where you had to justify why your best engineer deserved a raise that was 10% above the band ceiling. No parking lot pothole that took 14 years to fix. My wife asked me, about 3 months after the close, whether I felt vindicated. I thought about it for a minute. Not vindicated, I said. Just correct. She understood what I meant. The whole situation had never really been about the money, or about being proven right, or about watching someone else face consequences. It was about the fact that the work was real and worth something, and somewhere along the way, the people making decisions had lost track of that. What happened afterward was just what happens when that kind of mistake catches up with itself. I'm 51 now. I drive to the same office building I've been going to for 2 years, park in a spot with my name on it, which I find slightly embarrassing but my assistant insisted on, and spend my days doing work I believe in, with people I chose, building on a foundation I own. My COOs, the one who slid that paper across the table, sent me a LinkedIn connection request about 8 months ago. I declined it, not out of bitterness, but because I genuinely couldn't think of a reason to accept it. We didn't have anything left to say to each other that hadn't already been said in a boardroom in Waterloo on an October morning in exactly 12 minutes over the sound of fluorescent lights humming. He'd looked at what I'd built and seen a cost to be cut. I'd looked at what I'd built and known exactly what it was worth. That's the whole story, really. The rest is just paperwork.